you just got married, or maybe you are in the thick of planning a wedding right now. You have meticulously thought about the venue, you've debated the honeymoon destinations, you've probably even had that slightly awkward conversation about merging bank accounts. But have you thought about what happens to all of that if the unthinkable occurs?
Yeah, it really is the ultimate blind spot.
Yeah.
Getting married, well, it fundamentally changes your legal and financial status in the eyes of the government.
Right.
It's a beautiful romantic commitment, obviously, but beneath that, it is a binding legal contract.
Hmm.
And if you don't take control of your own estate plan, local inheritance laws, they just immediately step in and take the wheel.
And that brings us to the mission for today's deep dive. We are digging into this really highly detailed guide from Weddizer, and it's titled Estate Planning Basics, Wills and Beneficiaries After Marriage.
Which is a fantastic resource, by the way.
It really is. And the goal here isn't just to, skim the surface. We are looking at the specific mechanisms of how you protect a shared future. And frankly, we need to shatter this persistent myth that estate planning is something you only do if you have, I don't know, a family office and a yacht.
Exactly. It's for everyone.
Yeah, skipping this is essentially like spending a whole year building this state-of-the-art custom dream house and then deciding not to put any locks on the front doors.
Oh, the state will absolutely install its own locks for you, and they might actually refuse to give your own spouse the key.
Wow. Okay, that's a scary thought.
It happens all the time. Most people just assume that because they are legally married, their surviving spouse automatically inherits everything by default.
Right. I mean, that's what I would assume.
But depending on the state or country you live in, and especially depending on whether you have children from a previous relationship or, even living parents, the law might carve up your assets in ways that completely contradict your intentions.
Which means we need to look at the bedrock of all this, right? The will. Now, anyone listening to this deep dive generally knows what a will is. It's that foundational document where you appoint executors, name guardians for future children, divide up your assets.
Right, the basics.
But the Weddizer guide throws a massive wrench into this right out of the gate. They highlight this structural trapdoor that catches incredibly savvy people off guard.
Beneficiary designation.
Yes. The guide points out that some of your most highly valued assets, so your 401k, your pension, life insurance policies, payable on death bank accounts, they do not follow the will at all.
They bypass it completely.
Completely.
Completely. You can kind of think of your estate like a theme park. Your will is the general admission line. Every asset in that line has to go through the turnstiles of the public probate court system, being checked and validated.
Okay, I follow that.
But a beneficiary designation on a retirement account or a life insurance policy, that's like a VIP fast pass. It skips the probate line entirely and goes straight to the person named on the form.
Okay, let's unpack this because I want to explore the actual legal mechanics here. It sounds like a glitch in the system. Are you saying that I can go to a top-tier attorney, pay them thousands of dollars to draft this legally ironclad will that explicitly leaves absolutely everything to my new spouse?
Yes.
But if my old retirement account from a job I had 10 years ago still has my ex-partner listed as the beneficiary, my ex gets the money.
Your ex gets every single cent of that 401k.
Are you serious?
Totally serious. And there is virtually nothing your current spouse or your high-priced estate attorney can do about it.
How is that even legal? If my most recent will says I revoke all prior agreements and leave everything to my wife, shouldn't that supersede some form I filled out in my 20s?
You would think so, right? But it comes down to contract law versus probate law. What's fascinating here is that when you open a 401k or buy a life insurance policy, you are signing a private legal contract with that specific financial institution.
Oh, I see. It's an agreement with them directly.
Exactly. That contract dictates that upon proof of your death, they will release funds directly to the person listed on their internal forms. It never even enters your estate in the eyes of the probate court.
So the will has absolutely no jurisdiction over it?
None. The financial institution is legally bound by federal law, specifically RISA, in the case of many employer-sponsored retirement plans, to just distribute the money to the named beneficiary on file.
So wait, someone could accidentally disinherit their own spouse just because of a piece of HR onboarding paperwork they rushed through during their first week at a job a decade ago?
It happens way more often than you'd want to know. And, it isn't always an ex-partner.
Right.
Very often, a young single person starts a career and they just list a parent or a sibling as the beneficiary.
Because they don't have anyone else yet.
Right. Then decades pass. They get married, they have kids, buy a house, write a will, then they pass away unexpectedly. Their surviving spouse is counting on that $1 million life insurance policy to pay off the mortgage and put the kids through college.
But the paperwork still says the brother.
Exactly. The institution cuts a check to the deceased person's brother. And while you might love your brother, the intention was obviously to protect your new household.
Man, if you are listening to this right now, I want you to just mentally scan your own financial footprint. Think about that Fidelity or Vanguard account you haven't logged into since like 2019.
Or the life insurance policy your job provides as a fringe benefit.
Exactly. The takeaway from the source material is really stark here. Checking and updating these designations, it takes about 5 minutes of navigating an online portal, but failing to do it can completely derail your family's financial survival.
It is easily the single highest ROI task you can do for your financial security after getting married. Just go verify the forms.
But let's shift gears and look at the timeline here. Because wills and beneficiary designations, they share one crucial requirement, which is that they only kick into action after you flatline.
Right, after you're gone.
What happens if an unexpected medical emergency strikes? Let's say you're in a severe car accident. You are incapacitated, you're in a coma for 3 months, but you are still very much alive.
Well, this is where estate planning stops being about the end of life and really starts being about risk management for the living. The Weddizer Guide heavily emphasizes 2 specific mechanisms for this.
The financial power of attorney and the healthcare directive, right?
Yes, those 2 are critical.
So I want to push on the financial power of attorney first because I think the common assumption is, hey, I'm married, we have a joint checking account. If I'm in a coma, my spouse can just log in and pay the electricity bill. Why do we need a whole separate legal document for that?
A joint checking account will absolutely keep the lights on, sure. But what if the situation is more severe? What if you need to be moved to a specialized long-term care facility and the only way to afford it is to sell your jointly owned home?
Wait, if the house is jointly owned, my spouse can't just sell it.
No, they can't. Real estate transactions require the signatures of all owners on the deed. If you are in a coma, you cannot sign those closing documents.
Oh, wow.
Yeah, without a durable financial power of attorney, which is the document that legally authorizes your spouse to sign on your behalf, your spouse is completely stuck. They cannot sell the house. They can't access your individual retirement accounts to pay for your medical care.
That's terrifying.
They can't even file your joint tax return.
So what is the recourse? If my spouse is in a coma and I desperately need to sell our house to pay for their care, but we never drafted a power of attorney, what do I actually have to do?
You have to hire a lawyer, go to court, and petition a judge to grant you a conservatorship or guardianship over your own spouse.
I have to sue for the right to manage my own family's money?
Yes. And it is a slow, incredibly expensive, and deeply invasive legal process. A judge actually has to evaluate your spouse's medical incapacity and then officially grant you the authority to act.
So you are adding a grueling legal battle on top of an already devastating medical crisis.
Exactly. And a financial power of attorney just bypasses all of that.
Right.
It's simply a document that says, if I am unable to make decisions, my spouse holds the keys.
That reframes the entire concept for me. It isn't just paperwork. It is a firewall against administrative disaster during the literal worst moment of your life, which I guess naturally leads into the medical side of this equation, the healthcare directive.
Right, also known as an advance directive or a medical power of attorney. This functions on a very similar principle, but obviously it dictates healthcare choices.
Okay.
It explicitly names the person you want making medical decisions for you if you cannot communicate. And critically, it outlines your specific preferences regarding life-sustaining treatments.
Now, the source notes that newly married couples almost universally choose their spouse for this role. But I'm looking at the mechanism of why the document matters so much. Even without a document, a hospital is generally going to look to the spouse first anyway, right?
Yeah. Usually, yes, they will. But think about the psychological weight of that situation. Without clear written instructions from you, your spouse is left standing in a hospital hallway, just agonizing over what you would have wanted.
Oh, that's heavy.
It really is. And what if your spouse disagrees with your parents about the course of treatment? You now have a family tearing itself apart in a waiting room over a life or death decision.
I can't even imagine.
By putting your preferences in a legally binding directive, you completely remove the burden of choice from your spouse's shoulders. You are giving them the authority to simply point to a piece of paper and say, look, this is what they wanted, my hands are tied.
It's basically an incredible act of care. It's taking all the guilt out of the equation for them.
Precisely.
Okay, so we've established the baseline here. We have the will for the general assets. We've updated those VIP fast pass beneficiary designations to prevent accidental disinheritance. And we have the living protections, the power of attorney, and the healthcare directive. But, families evolve.